Good morning and happy Friday, and welcome to today's webinar as part of the Elville webinar series. Today's topic is the essentials of estate planning and elder law, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome, we're glad you're here. You as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout the presentation to address them. Your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not receive the presentation, it is available in the section marked handouts in the panel on your screen to download at this time. For our friends that are advisors, CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So per my attendance records requirements, as always, please email me your ID number, and for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Also, everyone will receive a post-webinar feedback email right after the presentation, and we always ask that you please take just a couple minutes to fill out this simple survey to offer us your feedback about the presentation. We look forward to being a resource to you now and in the future here at Elville and Associates, and we always value your feedback, and we do read every comment. So briefly, I'd like to offer you an overview about our firm and share a little bit about Steve before we get started. So Elville and Associates, we were founded in 2010 in Columbia by your managing principal and lead attorney, Stephen Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and we're coming to you live from the Columbia location here in the Gateway community. Our mission, as it always has been and always will be, is to offer practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We offer a lot of education here at Elville and Associates, and we do that in a number of ways. Through our planning processes with our clients, we also offer over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited CCP by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion every time with every client here at Elville and Associates. Also, a little bit about Steve. Steve's work as an attorney the past 20+ years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. He's a member of a number of membership organizations throughout the country, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association, a very seasoned speaker if you haven't heard him speak before, always presenting at many webinars, workshops for businesses and their employees, conferences, and CE events each year. He was also named to the Maryland Super Lawyers list for a 6th time in 2021 and a 5th consecutive year, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I am privileged to be the executive director of, and we had a great week here at the Elville Center. We delivered instruments to 4 schools, about 40 different instruments, and it was a wonderful time visiting those schools. And if you want to learn more about what we do at the Elville Center, please reach out to me and I'll be more than happy to spend time sharing our story about who we are and what we do at the Elville Center. And we are very proud of the work that we do, and we can't do it without donors and supporters. So please let me know if you'd like to learn more. So with all that said, we're going to get started. We're going to start with a brief poll, and that poll, which I'm going to launch right now, is what brings you to today's webinar. What is the state of your estate planning? And the choices are, I am new to estate planning and need to get started. Second, I have a plan in place, but it is outdated and needs updating. Third, I feel my plan is on solid ground, but education is always great. And lastly, I'm an advisor here to learn to better serve my clients. So if you can select the choice that best suits your situation, get a feel for who is joining us today. And we'll give it about 30 seconds. And the votes are coming in. Give it a few more seconds here. Okay, so we have 29% saying I am new to estate planning and need to get started. 41% saying I have a plan in place, but it is outdated and needs updating. And that is not out of the norm. We see that a lot. 18% say I feel my plan is on solid ground, but education is always great. And 12% say I'm an advisor here to learn to better serve my clients. So welcome. We have a pretty diverse crowd here, Steve. So welcome everybody, and I'm going to turn it over to who you really want to hear talk. Steve Elville. Steve, I'm going to make you the presenter. You should see that button pop up in just a second. See that, Steve?
I am still waiting for it, Jeff. Let's see.
Still waiting. Good. Let me try it again. How about that?
I see it. Thank you so much. All right. All right. And good morning. Thank you so much, Jeff. I'm just going to get myself situated here with my screen. And we're going to start the slideshow. And good morning, everyone. And I guess happy latter part of September. It's going to be Halloween soon. It's amazing. And through the miracle of technology, we're able to come to you today from wherever you are. And I thank you for your attendance. It's a beautiful day outside. It's supposed to be a beautiful weekend ahead if you're in Maryland. So again, thank you for joining. I want to thank Jeff for his wonderful work. I couldn't do it without him. He's a wonderful moderator. And he's been talking to you about the presentation, which I want you to use as a tool today and after today, if you're so inclined. And please feel free to ask Jeff questions as we go through this webinar. He's a pro. Jeff will stop me if you have questions, but I will also stop along the way. Again, it's my privilege to educate today, and this particular webinar really represents the core. It's really the core of what we do here at Elville and Associates, no matter how wealthy you may be, or modestly wealthy, or not so wealthy. It doesn't matter what your economic status is. These principles, these core principles of estate planning and elder law are what you need to know to be able to take next steps. And thank you for the poll, Jeff. I noticed that about 70% of the people on the line here either have no planning or need to update their planning. So that tells me largely who to communicate to today, as well as our other attendees. So that's what I want to do today, is share with you concepts that you can walk away with and actually use in a substantive way for your knowledge as you do your planning. One of the things we find is that the more educated a client is, the better the planning will be. That's our philosophy here, and we think that statistics prove that. So the more educated you are, the better. You are a very, very serious person if you're willing to sit through this morning, and we hope to give you something of value. So with that said, I'm just going to launch right into the presentation. And again, I appreciate you being here. So we're going to talk about our goals. Everything in estate planning and elder law planning is goal driven. And so we're going to have goals for this presentation. What is an estate plan and what is the process? A lot of people are mystified about this whole subject. What is the process? Many people are mystified because when they go to do estate planning, there is no process, which is not your fault, not their fault. But we want to talk about a process because without a process, we can't really succeed too well in estate planning. Why do many or most, I will go as far as saying, estate plans actually fail or they implode? They don't work the way they're supposed to. And what can we do to actually avoid this? We have a presentation that we will not be getting into today, a separate presentation called Being Intentional or Intentionalism in Estate Planning. And in that webinar, we talk about how to avoid planning failure, but we're going to touch on that today because planning failure is a fact, just like the randomness of life today is kind of a fact. We don't want randomness in our plan. We want process and we want to avoid failure. We're going to talk about very basic fundamentals, wills versus trusts, probate versus non-probate. That's what you're here today to learn, is the fundamentals. We're going to be talking about elder law and taxation and the basics of asset protection planning and what are these concepts in today's world. And we don't want to just give you information for the sake of educating you. We want to give you practical ways to take next steps. So just remember, we want you to be educated, we want you to be informed, and we also want you to be able to move forward and take steps towards a better planning for yourself in updating old planning if you have old planning that needs to be revisited. So we need to understand that estate planning should be a process, and we need to understand that process. And part of that is what I mentioned earlier about goals and being goal driven. So why should we plan? So let's get into that first. Well, again, we want to have a purpose, we want to have a destination with our planning, and that's going to get us a long way. It's an upward climb to do great planning over a lifetime, but this is our first step, is to have a goal and a purpose. So some people, it's all going to be individual to you. Some people want to provide certainty. They just want to take out the randomness of the planning. They want to facilitate smooth administration. They want to make sure that there's no glitches along the way, minimizing the cost of the administration process. When I'm talking about administration, I'm talking about administration after someone passes away, whether that's a will where there's probate or a revocable trust where there's no probate, hopefully, because hopefully that's been done properly. Some people have a goal of protecting spouses, protecting them from bad spouses in the future, like new spouses, or protecting from bankruptcy or creditors or car accidents and those kinds of things. And the same kind of protection for children or grandchildren. Some people have a goal of minimizing or eliminating taxes. This is now back in front and center again because of the Biden administration's current proposals that are on the table, especially from the House of Representatives right now, about raising taxes, eliminating certain tax shelters, reducing estate tax exemptions. So the squeeze is on to get more money into the IRS, to have a greater and more robust IRS. So some people are going to want to plan to avoid that. And for a long time, we've been able to sail along pretty easily with regard to estate taxes and corporate taxes and individual taxes. But now taxes are going to go up. It's just a question of what's going to happen. Some people have a special purpose. They have a charitable purpose, or they have a special needs child. They have something that's driving their planning. So it's going to be all up to you. It's going to be all individual according to your ideas and your needs. But our goal, and a good estate planning goal, is to attain what your definition of estate planning really is. Now, you may have seen in the couple of slides prior to this that estate plans can fail. They can not work exactly the way that we want them to work. And the way to avoid that, and for those of you who are a little bit shocked right now, let's just take 1 minute on this. Estate plans can be great, the documents can be great, but what I'm going to illustrate to you in this program is that no matter what the documents say, the documents could be great, they could be okay, but the assets have to flow properly, and estate plans can fail because assets are not flowing properly, or the documents are not understood, or the documents are not followed by the trustee. So plans can fail, but getting back to basics, how do we avoid that? Well, we avoid that mainly by understanding that estate planning represents more than just a set of documents. If you go and obtain a set of estate planning documents, a will, power of attorney, advanced directives for healthcare, a revocable trust, a will, powers of attorney, advanced directives for healthcare, you have a physical set of documents. But those physical documents do not represent the real underlying estate plan. They are only a part of it. And understanding that is the first key to avoiding failure. So for those of you who have not cheated and you haven't looked back in the presentation, I'm going to give you a question that I'll give you a couple seconds to think about. I want you to think about that most people in this country have no planning. I'm going to say the vast majority of people, 55 to 60% or more. And in younger populations or demographics, the figures are as high as 80% have no estate planning. So that means that only a minority of people do estate planning. And so the 45% or less of people who do estate planning in this country, here's my question for you. When those people, the minority of people who do planning, when they actually go to do their planning, number one, how many years go by after that planning before there's a follow-up visit? How many people revisit their planning, and how many years go by? So I just want you to consider this for a second. But the answer that we're aware of is it's around 20 years. We think it's about 19 years at a time for those people who are astute enough or progressive enough to do their planning. They still allow around 19 years at a time to go by between planning visits. So that is a recipe for planning failure. So we want to make sure at least of two things right up front, that we're not treating the estate plan as a set of physical documents. It's more than that. It is more involvement than that. It is more commitment than that to make an estate plan work over a lifetime. And as part of that, we sure do want to do a whole lot better than having 19 years at a time go between visits. So traditional estate planning is basically what I was just describing. It's a set of documents. There's no process. The law firm or the attorney involved, there's just no education. There's no process, and we don't want that. So I'm not going to spend a lot of time on that because I've been pretty clear on that so far in this presentation. What we want is a process-driven system. We want an educational-driven system with a partnership where the client and the attorney or the law firm actually work together in collaboration with financial advisors, in collaboration with CPAs and tax preparers for the best outcome. That's what we're looking for. The traditional estate plan, I won't focus on this, but we need to recognize it. The documents are the plan. There's no follow-up, there's no education, and the chance of failure goes through the roof. So we want a process, and it doesn't necessarily matter what the process is as long as it's comprehensive. And we like to describe it very simply as a design and implementation process. This is a process where someone comes in and they think through the issues, they are educated about the issues, they have a chance to evaluate the issues and have a space to think, a place to think, a time to consider in this very fast-paced world we're living in today. And then clients need to be given a chance to maintain and update their documents. A client, even their financial advisor and the client, could have a desire to continuously maintain the program, but if there's no way to do that, if there's no program with the law firm to do that, then the plan has a potential of failure. Not because of the client, but because of just the momentum of life and how these things tend to get away from us. So it is a process. It has to be a recognized thing. And then final administration now becomes much simpler, much smoother. So design and implementation with the process, maintenance and updating with a process, and then final administration with the proper process. This is what is the key to avoiding failure. So a process-driven or educational type plan incorporates these three major phases, no matter how they're carried out. There's an emphasis on education. The life process is the plan, not the documents. It incorporates maintenance and updating. And of course, in a perfect world, we want to be dealing with a law firm that cares about clients and ensures that clients are in a partnership, and also provides, the highest and best technological, legal technical planning as well. Let's define estate planning in any way that you would like, if you would like to take a few minutes to think about it. But on a very, very fundamental level, estate planning is about disposing of your property the way you want, to persons or organizations of your choice, at the lowest possible cost. I'll repeat that again. Estate planning is about disposing of your property the way you want, to the persons or organizations of your choice, at the lowest possible cost. That's a very general definition. For those of you who are interested in seeing our intentionalism presentation, we define estate planning a little bit more broadly and a little bit more technically beyond this basic definition. But this is one that you can work with, and I hope you will at a very fundamental level. Let's now talk about one of the things that drives the questions that clients have and the public has, basically, about estate planning. Some of these things are things that you've dealt with personally, perhaps. Maybe you've had a relative die, heaven forbid. Maybe you've dealt with the probate process. Maybe you've had parents that had revocable trusts as substitutes for wills, and you have some experience. But I'm going to act as if you know nothing about this. If you take this slide, even though it looks very straightforward, this slide really encompasses a very broad summary of the entire probate process. So what is probate? Probate is the process of proving a will to be valid, okay? So whether we have a will or not, if we have probate assets, if we have assets that are not jointly owned, meaning they're in the sole name of the person who passed away, with no joint owner and no beneficiary, those assets are going to pass through probate. And that's going to be whether there's a will or not. Now, a will, of course, is going to direct how those assets should be distributed. And the probate process, as I mentioned, is the process of actually proving the will to be valid. So probate in Maryland is a pretty robust process versus places like Virginia, and I am not barred in Virginia, but places like Virginia where my colleagues tell me that probate is much less onerous. So we are still dealing with a pretty onerous or robust process in Maryland. So this particular process, opening the estate and understanding what assets are subject to probate, filing the inventory, understanding the claims of creditors periods, and providing an accounting to the Register of Wills and so forth, this is all part of probate. So the discussion about wills versus trusts is really a discussion of probate versus non-probate, and that's what we're really going to focus on here today. You'll notice that the cost of probate here, I'm estimating at around 4 to 7%. Now, this was a statistic years ago by AARP magazine that said the average cost of probate across the country is 4 to 7%. And this is including places like California and New York. Now, remember, it does not mean that probate will cost this amount. Probate can be much less than this if our children or siblings or family members carry out most of the probate work themselves without a commission. But these figures include commissions and fees and lawyers and CPAs and all of the players that are involved on average. So that's what that number represents. A will structure, and this will hopefully answer two questions. What does a probate type plan look like? And it also will illustrate what a will-based plan looks like. So a will is usually accompanied by what we call the ancillary documents. powers of attorney, and advanced medical directives. So if we look at a will as kind of a three-legged structure, a three-legged stool, so to speak, we have the will, which is the driving force, and then we have the incapacity planning documents. And as we get towards the latter end of the presentation, we're going to talk about incapacity planning. This is a will-based structure. Now, many of you and many people across the country will ask, what is a revocable living trust? A revocable living trust is a structure that will avoid probate if it is properly done. And that's why you see an asterisk next to the avoidance of probate. It must be properly done. It has two steps. The first step is the development of the revocable trust, just like the development of a will and the implementation of that document. But the second step, above and beyond the education and the implementation, is to actually fund or transfer the assets or align the assets that the person has with their revocable trust. So a revocable trust will fail. It will not work the way it's supposed to if the assets of the individual or the couple are not properly structured, aligned, funded, or retitled into or beneficiary designated with and around the trust. So that process we call funding and alignment at our firm, asset alignment. So that is a key second step. Once you have done those two things, now we have a revocable living trust that will actually do what it's supposed to do. And what is it supposed to do? It's supposed to avoid probate. So probate avoidance is the driving force of a revocable trust plan. It's a private document. It is a preferred way to go for many people, but not all people. It does not protect against creditors. It doesn't provide tax savings in and of itself, but the cost of administration can be much lower with a revocable trust if it is done properly with the proper asset alignment and maintained throughout life. So this is what I want you to be thinking about: avoiding plan failure, whether it's a will or a trust, and no matter what structure, a will or a trust, making sure that assets are properly aligned. Here's a revocable trust structure, a very simple diagram. Here, the revocable trust has taken the place of a will as the driving force of the planning. And the will has taken second place here. You'll see that there is a will that is a backup to the revocable trust. You'll also see powers of attorney and advanced directives, because we still have to plan for incapacity. And for those of you who want to know the little nuances, the revocable trust is also an incapacity planning tool and is really a preferred way to go to avoid guardianship of the property, which of course we're avoiding at all costs in our estate planning. So revocable trust versus wills, we have basically the conversation of probate with wills, or even if we have no will, probate, depending on the assets, and then the avoidance of probate with a revocable living trust. Jeff, I'm going to stop there just to see if there's any questions, because we've been going now for about 20 minutes.
Thanks, Steve. We do have one question. I think just a clarification. You were talking about probate regarding a will-based plan. A lady was asking confirmation that 4 to 7% is regarding the total value of the estate, please.
Yes, thank you for that question. If I'm understanding your question correctly, that would be right. The way Jeff phrased that 4 to 7% is the amount of the estate to be accounted for. It would not include the amount of IRAs and other things that are hopefully properly beneficiary designated and are avoiding probate. Things like life insurance would not be part of probate unless there was no beneficiary.
Okay, thank you. That's it for now.
All right,
sure
thank you, Jeff. Thank you for that question. So let's now, we've talked about wills versus trusts. Let's talk about the third category, and this is the way of understanding non-probate transfers. We have wills, we have revocable trusts, and now, in addition to a revocable trust, these are many things that you recognized just instinctively: joint ownership, beneficiary designations, life estate deeds, a deed where at the death of someone it can transfer without probate to others. Transfer on death designations, these are designations in a brokerage type account, generally speaking. Payable on death designations at a bank. In trust for accounts, which I've seen mainly in New Jersey and in some of the northern states, not necessarily in Maryland have I seen a lot of these, which are similar to transfer on death accounts. So it's important to understand that there is this third category of beyond wills and trusts where you can actually leave your assets in a non-probate fashion directly to beneficiaries. In estate planning, we generally don't use these as the primary vehicle of primary way of transferring assets. And why not? Well, there are many reasons for many types of planning, but generally speaking, we don't use this because clients and families, basically, they want some certainty about how assets are ultimately going to flow. If everyone in the order of death dies exactly in the order that we predict they will based on their health and their age, mainly their age, then everything will work perfectly, generally speaking, with beneficiary designations, with joint ownership, with transfers on death. But if the order of deaths is not the way we think that it's going to actually turn out, and many times that's the case, then these things can go awry and assets can flow in ways that we don't anticipate they're going to flow. So we don't recommend, and most clients would not rely on these non-probate transfers, as we call them, devices, just as the sole mechanism to drive their estate planning. For example, let's say that I had a child, and let's say that I wanted to protect my child or my grandchild in further trust. I wanted to leave a further protective trust for them. Well, if I use these beneficiary designations or transfers that are automatic, it may go to the child or grandchild in a way that I would not want. It would go outright, let's say, or it would go to a grandchild who happens to be a minor, and there's no control mechanism to manage that money until that person is older. There are many, many reasons why we don't want to rely on these non-probate transfers, but they are tools, and we use them as tools in planning, either on the estate planning side, the elder law side, or the special needs planning side. But these are important things to be aware of. Now, just as an aside, beneficiary designations alone are an incredibly important thing, because without proper beneficiary designations of retirement plans can be subject to probate and immediate taxation, basically. So we have to double check and recheck our beneficiary designations as part of basic planning, because even though we use wills or trusts for IRAs, 401ks, 403bs, and other retirement plans, we definitely are going to be focused on beneficiary designating those, because that is the nature of those assets. Those are beneficiary designated assets. We don't want to have a large IRA that fails because of a lack of a beneficiary. Now, the next two slides illustrate what I was talking about earlier. Here we have a great will or trust, and you on the line here today may already have a great will or trust, or maybe it just needs to be updated. But look at how the assets are passing. So I was speaking to a young associate here at the firm this morning, and we talked about someone who had passed away and left all assets by joint ownership. So that's a prime illustration here. Maybe that was by design, and there was nothing wrong with that. But look at what happens. We have a great will or trust, but if our intention was not to leave assets outright, then what happened here is all the assets passed to the survivor, and they did not get controlled by the will or trust. And that's fine if that was the intention of the planning. But if it's not the intention, then the ownership and the way the assets are designated is going to make a big difference. And we want the will or trust to be employed, meaning we want it to be in play in the planning, or we intentionally don't want it to be employed. The key is to know when we're doing that and when we're not doing that. Here is a better way of looking at this. We have a great will or trust because you had the greatest will or the greatest trust in the world created, but the assets were flowing in a way that just didn't make sense. The assets didn't flow to the further trusts for the beneficiaries. The assets didn't flow to the further trust for a surviving spouse. So everything is goal driven, and the funding, or the alignment of assets, as we call it, is the key. That has to also be in coordination with the documents. All right, so thank you for staying with me so far. We've been going about 30 minutes in this presentation. I'm now going to switch gears to some other aspects of planning, the nuances of incapacity planning. We at Elville and Associates, we are the only law firm I'm aware of, I could be wrong, but the only one I'm aware of that we actually spend an entire meeting discussing the nuances of incapacity planning with clients, powers of attorney, advanced directives, and now the medical order for life-sustaining treatment. Remember that we have people today, you do and I do in our practice, we have people living to well over 100. We've had many clients live to 102, 105. Some of you know people that are more senior than that. What we want to make sure of is that we have flexibility in our planning, if that is appropriate. And the only way to have flexibility in the planning is the proper financial powers of attorney and the proper advanced medical directive populated with the proper agents, the financial agents and the healthcare agents. If we have those things in place, then we're going to avoid guardianship. On the property side, we're going to avoid guardianship of the property. On the medical side, we're going to avoid guardianship of our person. And in doing so, we are enhancing our own self-determination and our independence throughout the rest of our lives. And this is, of course, contingent on family cooperation, you having people that you can rely on, people that are reasonable, people that are going to advocate for you, people that are going to take their fiduciary responsibility very seriously. And is that a big thing in today's world with COVID and all of the threats that we face in our lives today? That is a huge thing. And as I move on from this slide, and hopefully I've already said enough to kind of get your attention about powers of attorney and advanced directives, some of the greatest estate planners that we have in the United States agree that a financial power of attorney is possibly the most important document that any person can have. Now, this is not to diminish the advanced medical directive, which some people feel is the most important document. But from a planning perspective, the flexibility of a properly designed financial power of attorney is possibly the most important thing in estate planning. I'll leave you with that thought. Now, you'll notice as I now kind of switch back to the prior slide, you'll notice if you look closely, I'm articulating here that you should have financial powers of attorney, that's plural, the Maryland statutory form, along with a general durable power of attorney. And the idea here is that in 2010, Maryland developed its own statutory form. Now, this was long time coming. This was very important. It now put us on the same playing field as DC, District of Columbia, and New York State and other states that had a statutory form. Maryland power of attorney laws were in dire need of reformation, and this did it. So now we have a statutory form that is enforceable by law, and there's two types. There's a long form, which is a very broad power of attorney, and there is a short form. We in estate planning generally use the short form along with a customized general durable power of attorney for kind of a dual approach. And that's something we could discuss further if it's confusing, or we can take questions here about it later. But I want to show you that the statutory form, the simple Maryland form, which basically can't be customized too much. In other words, we can't really do what we would like to do with this form for customization, but we can use it for what it is good for, which is its enforceability and its teeth. It's got teeth about the responsibilities of the agent. But as you read through these next several slides, which I'm not going to put you through every single one of these bullet points, you'll see that the statutory form in and of itself would be a really good thing for you to have, but it's not going to be enough for true estate planning, for true broad structured estate planning. I'll give you an example, and it's a very simple example and hopefully appropriate. The Maryland statutory power of attorney is for the average person. The average person who lives in Maryland, no matter what your occupation is, you can have a power of attorney. No matter what your economic status is, you can have a financial power of attorney that works. That is what is public policy, and that's why the statutory form exists. And also to cut down on fraud and abuse. But in estate planning, we know that the average person does not do estate planning. We know that only above average people statistically, and I mean that very sincerely, do estate planning. So the Maryland statutory form alone is not enough. These bullet points are going to illustrate the key ways that we need to enhance powers of attorney by using a second power of attorney along with a Maryland form. So advanced estate planning in Maryland generally, whether it's with Elville and Associates or not, is represented by the use of dual powers of attorney in the planning, because we need to cover many, many more bases of flexibility. That's what we're really talking about with powers of attorney. Flexibility for the future. If I don't have a financial power of attorney and I became incapacitated, then my agent would not have the flexibility to be able to do what is necessary to take care of me, to take care of any person who is dependent on me. And God forbid, if I needed to preserve some of my assets for long-term care or whatever the situation may be, there is no flexibility basically in a guardianship. If someone has to petition for guardianship of my person or property, they will have very little flexibility inside of that guardianship versus what they could have had if we were able to deal with a privately drafted set of powers of attorney and advanced directives. Speaking of advanced directives, the advanced directive is the most important document for some clients, and I don't blame them. We encourage you to basically customize your advanced directive. This may seem counterintuitive, but there really is no set form. There is no one format. There are no limitations within reason of what you could say in your advanced medical directive for your health. Remember, we want you to consider, and it's not required, we want you to consider personal preferences. What do you like to eat? What if you ended up in a place where you didn't really anticipate ending up? And what are your food requirements? What are your communication requirements? Making sure you have your cell phone. Simple things. Have you made your end of life decisions? Have you customized your advanced directive as much as possible? Have you thought about your final arrangements? These are really, really big things in today's world, as I don't have to tell you about that. And the only thing that your family or your loved ones or your friends or your whoever your agent is, the only thing they will really know about your healthcare preferences, other than what you've told them during your lifetime, is what you've articulated in your advanced medical directive, or what you articulate them or are able to articulate at a time of crisis. We encourage you to customize the advanced medical directive and to keep it updated. It's not required. The Maryland form, the Maryland Attorney General's form, is only a recommended form. There are other forms, such as the 5 wishes, and we want to work with any form, although we do recommend the Attorney General's form because of its flexibility and customizable nature. We do embrace any form that a client wants to use, generally speaking, but we will always advise you along the lines of what we think is best. The medical order for life-sustaining treatment has been law in Maryland basically since 2014. It was a national initiative in 2013. Many of you know what a MOLST form is, medical order for life-sustaining treatment, after all these years. It is not a medical directive. It is a medical order. So education about what is a MOLST form, education about the fact that the MOLST form is required in Maryland. If you or I end up in a facility, we are going to have a MOLST form completed. It's going to be completed by a nurse practitioner or a doctor. And we need to be ready for that. We need to understand it. We don't need to worry about it, because some of you will worry about this MOLST form. But it is something that we need to understand. How does this work in Maryland healthcare decision making? And if you have questions about that, we can talk about that in person. Jeff and I will be happy to send you the information we know exists about MOLST. And of course, you could go to the Maryland Attorney General website, which we've listed here, and you could actually read about healthcare decision-making policy in Maryland. So you need to be aware that MOLST is an educational issue for you and your healthcare agents. Jeff, I'm going to stop again to see if there's any questions.
Thanks, Steve. We do have 3 questions, really good questions. So for those out there, thank you for your questions. They do really help. So the first question is, if a wife is given guardianship of the person and property, can she add her name to a property deed?
Good question. That sounds like a specific situation that we would have to talk about in person, but in very general terms, I would say no. Again, this can't be considered legal advice because I don't know all of the situation, and this is not a client situation, but just generally speaking, a guardian is a fiduciary, and the guardian has to abide by the rules of guardianship as specified in the law and specified in the guardianship order. So my general response would be probably not as my answer, unless the court allowed it by court order.
Thank you, Steve. Next question. If a wife knows her husband has a will but cannot find it, should she file for personal representative of the estate and continue looking for the will?
Good question. This sounds again like a specific client situation that would need true legal advice. But generally speaking, I'll answer off the cuff. If someone has passed away and the survivors know that there probably was a will, then but we can't find the will, then what can happen is probably the person, if they are a person of high priority. So let's say the will would have named this person as the personal representative, but the will can't be found. The first thing I would do is probably see if there was a photocopy of the will, because a photocopy can be submitted to probate under certain circumstances if we verify the names of the witnesses or the signatures of the witnesses. And that would be my first approach. But if there's no copy and there's no will, then there is a list of priority of people who have the right to open an estate, and a spouse would be right up there at the top of the list of priorities. So generally speaking, I think that under those circumstances, a person wouldn't really have any choice but to go ahead and try to open the estate, even though the will could not be found.
Okay, thank you. Next question and last question for now. If applying for guardianship, do you need guardianship of the person if you have already been named in the advance medical directive?
That is a wonderful question. Thank you. So guardianship is the ultimate power that the court is the ultimate guardian, and the named guardian is really just the person who carries out the fiduciary duties, but the court itself is the ultimate guardian. So if a person has an advanced medical directive, that is considered to be an alternative or substitute for guardianship. That is preferred. That advanced medical directive hopefully names healthcare agents, and those healthcare agents, because they exist, they can make decisions for the person, meaning the principal. They can make decisions for that person because that's a private situation. There's no need for a guardianship. Now, with that said, there are times when there is an advance directive or a power of attorney with a listed agent, and there still is a need for a guardianship. Maybe the decision-making process isn't working because of family disputes, or there's some impediment to keeping the agent from being able to make the decisions necessary, or the agent is not well and there's no successor agents. So there are times when guardianship would still be needed, even if the person has an advance directive. But hopefully that is not going to be the situation ultimately, and hopefully is rare.
Okay, very good. Thank you. That is all for now.
All right. So as we now end up going into the latter part of the presentation, we're going to switch gears. We've talked about the basics of estate planning, the basics of goal planning and goal setting for estate planning. We've talked about the basics of incapacity planning. Now we're going to talk about the current tax environment, and we're just going to go through these bullet points relatively quickly. As I mentioned earlier, the current tax environment is one where back in March, Senator Sanders and then Senator Van Hollen introduced their tax bills. Then came the Biden American Families Plan. And now just recently on September 13th, we are seeing the House Ways and Means Committee introducing their plan into the reconciliation bill, excuse me. And now we are seeing what's going to come forward from whatever the Senate bats back and forth. So we have continually now the most unprecedented estate tax exemptions that we've ever had. 11.7 million per person, or over 23 million per couple that can be exempted from estate tax. Estate tax is 40% right now. Senator Sanders and others have proposed a graduated rate, I believe exceeding 55% in some cases. There's also been talk of getting rid of the step up in basis, or the cost basis adjustment at death that we've enjoyed for so many years. Maryland's estate tax exemption is 5 million. Maryland still has an inheritance tax, but it's not subject to all beneficiaries. It's only subject to those who are non-lineal descendants, basically. And what we have for married couples is this unprecedented and wonderful thing called portability, where a surviving spouse can choose to use the exemption amount of their deceased spouse relatively straightforwardly. Whereas in the old days, so to speak, many years ago, before I'm going to say 2012, it was going to be a matter of jumping through hoops to be able to use the estate tax exemptions. So we're enjoying this wonderful environment, but it's about to be curtailed. So the new tax planning bill that's going to come out, most likely, even though we do not know what it will do, actually, the proposal is for a new 5 million exemption instead of the 11.7 on the federal level. This means that many people who have increased their wealth dramatically during the last several years, those people may now be subject to estate tax, because instead of being able to exempt 23 million, adjusted for inflation, the 5 million is a little bit less than 6 million per person. So a little bit less than 12 million per couple, or a little bit less than 6 million per person is what we're probably looking at, although we really don't know until we see a truly approved bill signed by the president. Maryland will probably, in my opinion, lower its exemption from 5 million to some unknown amount if the federal exemption is lowered from 11.7 to 5. So that's the kind of environment we're living in. Income taxes are going to go up, probably to 39.6% again, from 37% as a maximum rate. Corporate tax rates are going to go up. The use of grantor trusts and other advanced planning tools beyond the scope of this discussion today is probably going to go away by the end, or be curtailed dramatically by the end of this year. So what does all this mean? This means that you should probably have your planning reviewed as soon as possible before the end of the year. You should collaborate with your financial advisor and your CPA and your estate planning attorney to get opinions about whatever strategies you should use if this kind of planning is going to be applicable to you. One type of planning may be very, very applicable, even though it's not intuitive. One of those things is a life insurance trust. If the exemption amounts are coming down, and if the government is going to take away the use of what we call grantor trusts, which is beyond the scope of this discussion, it could be very advisable for many people to put a life insurance trust in place before the end of the year. Life insurance trusts are typically used to shelter the amount of life insurance from being taxable in someone's estate. And now that the exemption amounts are going down, the use of life insurance trusts are going to increase again, but the government wants to curtail their use, or the easy use, of life insurance trusts. But from our understanding, if we get life insurance trusts in place before the end of the year, we're going to have a grandfathered situation for those trusts. So evaluating your estate tax situation, evaluating gifts that you've made, making sure you understand that if one spouse dies, the survivor will have the ability to port the deceased spouse's exemption. The government doesn't seem to be interested in taking away portability, thank goodness. There is still the possibility of having marital control over assets. There is still the possibility of protecting for remarriage. And we want to make sure before I end this discussion today, Jeff, to talk about the new spousal elective share law. But basically, what I want to want people to take away from this particular slide is that it's time. It's late in 2021, and it's time to evaluate tax situations for clients. If you have any concerns about this whatsoever, now is the time to be looking at what can we do to use our exemption amounts if we are of exceedingly great wealth compared to modest wealth. What can we do to not lose these exemption amounts if we need to use them? How can we use them? And should we implement grantor trusts and all these other potential situations regarding the current tax situation? Now, switching from estate planning concerns in the general tax sense to a long-term care or elder law type concerns, we are really switching from a focus on tax planning to a focus now on asset preservation. So what's the difference between estate planning and basically Medicaid or elder law planning? And that's our first bullet point here. Well, in elder law planning, we're focused on disability planning. We're focused on nursing home asset preservation. We're focusing on how to protect the spouse in the community if we're married, how to preserve assets for children or disabled children, special needs planning, housing, Social Security. These are all part of the broader sense of estate planning, but in elder law, we are not as focused on estate tax as we are in estate planning generally. We are still focused on income tax. Income tax is a big driver, but let me go down through this bullet point list in the time that we have. Asset preservation. Can I save assets for nursing home purposes? How does a spouse protect himself or herself from a nursing home spend down? How do I have the flexibility in my planning to be able to accomplish this flexibility or this asset preservation, no matter what the future may bring? These are the types of things that we talk about in elder law consultations. It's not uncommon for these kinds of conversations to arise during what I would call conventional estate planning sessions. We're working with a couple or a single person, and we're getting what I would call conventional estate planning documents in place, but there are concerns about asset preservation or how do I pay for long-term care. This is where we kind of go from estate planning, pure estate planning, into the world of elder law. Do we divest our assets? Remember, for elder law planning, we have to give up control in some way. If we want to, everything is goal driven, of course, and if we want to save assets, so to speak, from a Medicaid spend down situation or long-term care situation, we have to be willing to divest or give up control of assets. So some of this has to do with how do I do that without giving up total control? How do I do that without negative tax ramifications? How do I do that without allowing my children's creditors to get at my assets? How do I do that and maintain some semblance of control and common sense with regard to tax and other issues? So there's Medicaid focused planning in this area. There is veterans planning in this area, tax-free pensions that are available for those who are eligible, even though the VA tightened up its rules in 2018. There are still many viable strategies. And many of these strategies overlap, and we have to have that discussion. Now, as we work towards the wrap up of the presentation, thank you for sticking with me. We're going to go about another 10 minutes, I hope. I want to now shift to one of the major focuses of today's planning, which is asset preservation, asset protection. There are three types, in my opinion. So this is a very broad topic that could be confusing, but I want to break this out into three types: lifetime protection, long-term care asset protection, just like we just talked about for elder law, and then back to estate planning, asset protection at death. So three types of protection that I want you to be aware of so you can understand it. So lifetime asset protection is really not something we talk about a lot in elder care, but it's something that you need to be aware of in estate planning. If you're married, and I'm focused on married couples right now, I apologize for any single people on the call. Tenants by the entirety's protection, very big in Maryland, very big in Delaware. This is where we have the marital wrapper of protection on property. So if one of the spouses gets sued, that means that the other spouse could not lose their assets, and it just generally means that the property itself, the typical example is the marital home, cannot be lost in a lawsuit as long as the creditor doesn't sue both spouses. So if they only sue one, we have this basic level of asset protection. Very important. So it's important to know that in estate planning, for those of you who are thinking about planning, those of you who are thinking about updating your documents, tenants by the entireties can be preserved. So if you own your home as husband and wife or spouses, and you transfer that home into a revocable trust, for example, under new Maryland law in the last several years, you do not lose your tenants by the entirety's protection. Another thing to be aware of is that many of you have assets that are not retirement assets, but those assets are not owned as tenants by the entireties, for example, brokerage accounts, and they probably should be. You're not aware, maybe, that, and many people are not, that those assets could have the tenants by the entirety's wrapper on them. So not just real estate, but all assets that could be owned as spouses could be owned as tenants by the entireties. Even LLCs can be owned as tenants by the entireties. IRAs cannot, of course, and 401ks, but tenants by the entireties is a big issue to understand. Life insurance is protected from the claims of creditors if the beneficiary is your spouse or child. Annuities are the same. There is an element of asset protection. Qualified plans and IRAs, 403Bs, 401ks, IRAs, those are protected from the claims of creditors. But when we pass away and leave those assets to others, children, grandchildren, nieces and nephews, those people receive inherited IRAs, and those inherited IRAs are not protected from creditors. And therefore, for those of you who want protection for beneficiaries, we have to use trusts for those beneficiaries. Now, I'm going to mention something before I forget it. We're going to talk about marital protection just for a second. There is a new Maryland law called the New Spousal Elective Share Law. You need to be aware that a year ago, in October 2020, this law came into effect. It protects surviving spouses, and it means basically that your surviving spouse is entitled to a certain amount. And of course, many of you on this call who are married are going to leave everything to your surviving spouse, and this is not going to affect you too much. But the reason I'm making a big deal of it on this call is because you need to be aware that if you ever remarry, to protect yourself and your children, you should get a premarital agreement, a prenuptial agreement, for reasons that we won't have time to get into on this call today. That's a very big thing because of the new law. The other good news is that the new law provides certain amount of strategic fuel for elder law planning. It sanctions the use of wills that are used in elder care planning, which I'm going to talk about on the next slide. Before I leave this slide also, I want to talk about the Secure Act. So the Secure Act became law in January of 2020. And when we're talking about qualified plans and IRAs, getting back to the tax slide that I looked at a few minutes ago with you, just remember the Secure Act changes the way that we look at taxation on IRAs. So healthy beneficiaries are going to only have 10 years to take out their IRA instead of a lifetime of tax deferral. There are 5 exempt categories: surviving spouses, minor children, chronically ill people, disabled people, and of course the special needs trust for a disabled or chronically ill person, if that trust is drafted properly, and people who are less than 10 years younger. Those are people who are exempt from the Secure Act. The vast majority of people are subject to it, so we have to be aware not only that inherited IRAs, when they are left to someone, they are not protected from creditors unless we leave it to a trust for them, and whether we leave the IRA outright or in trust, it will be entirely taxable for the majority of people within 10 years or at no later than the end of 10 years. Now let's switch to the asset preservation subject in the long-term care context. So we talked about Medicaid and veterans benefits. So when we're talking about asset preservation outside of the day-to-day things like tenants by the entireties, and we're actually talking about what to do to preserve assets in elder law, we use Medicaid trusts. So the elder law community for the last 15 years has developed powerful tools. These are viable tools. Only a couple of states, and they're not usually in the Midwest, really have issues with some of these tools. But Medicaid asset protection trusts are very powerful, very flexible tools that most people should at least be aware of. Veterans who are subject to being able to get veterans VA and aid and attendance benefits or other pensions from the VA, we can utilize certain trusts for them as powerful tools. Use of wills, the third bullet point here, the use of wills under, the use of trusts, I should say, under wills. This was the elder care strategy that I referred to in just a few minutes ago in the prior slide. So let's say that you know or you have knowledge of someone who they're married and they have a spouse who is impaired. Well, under federal law since the early 90s, through the use of a will, and this is a trust that is established under a will, the assets that are left to that trust, if the well spouse dies first, and that's not always the case, if the well spouse dies first, there's an asset preservation opportunity there. Well, the new law in Maryland, even though it's beyond the scope of this discussion that I just mentioned, the new spousal elective share law, that's what is otherwise called the augmented estate, which you'll see here as the next bullet point. That new law sanctions the use of trusts under wills, even though that is a strategy we've been using for a long time. And it basically agrees or sanctions the idea that Maryland will have no estate recovery or long-term care recovery against a couple or a surviving spouse who dies and uses a trust under the will to provide a trust for their ill spouse. In other words, you can protect shares if the well spouse dies first. Crisis planning, it basically involves a 5-year look period. Many of you have heard of a look back period. I want you to think in terms of a look forward period. If we want to preserve assets from Medicaid, we have to look forward. I'm divesting my assets in some way to start the 5-year process where if I can preserve, and if I'm married, if my spouse can preserve his or herself long enough without long-term care Medicaid, if we don't apply for Medicaid within 5 years, then we will basically be avoiding a Medicaid spend down on those assets that we've transferred, and we can preserve those assets hopefully 100%. If we don't preserve assets 100%, if we don't get through the 5 years because of a crisis, there is always what we would call the rule of halves. This is a 50% rule. Basically, we can't save all the assets, but in elder law, subject to the current laws staying the same, we can preserve hopefully up to 50% of the balance of assets, even if we've done no advanced planning. And for married couples, I want to make sure that we're not skipping over the fact that even if we did no planning at all, except get basic documents in place, basic powers of attorney, basic documents that have lots of flexibility, the well spouse has the right under federal law and state law to protect himself or herself from a long-term care spend down and preserve hopefully as many assets as possible in that spend down. So there are many ways of preserving assets in elder law. If you know someone who has a long-term care situation, they're getting misinformation, they're upset beyond words, they're getting all kinds of mixed signals about what to do and what the law is. The thing to assure them is if they get proper advice, they will not lose their house. They're not going to lose all of their assets. That is a myth because there are strategies available to do that. Lastly, on this screen, life estate deeds are a method of being able to preserve a house. If someone wants to take a very simple, probably not flexible enough, but simple approach to be able to start the 5-year period and preserve a home. Many people are aware of this. It's called a life estate deed with no powers of sale. That is a Medicaid strategy to avoid probate and also hopefully preserve a piece of real estate without having to use a trust. But again, it does not provide for the same flexibility as a trust. And as we work toward the end of our presentation here, thank you for your attention. I'm going to go over one of our last slides, which is asset protection at death. So we've talked about asset protection during life. We've talked about asset protection in the long-term care context. And now we're talking about asset protection at death. So death is a horrible subject, but the good news is that if you plan properly in wills or trusts, it's easy to structure things to protect the beneficiaries that you love at death, whether these be spouses, and we would use something called a marital trust or a family trust, or it could be children and grandchildren, and we want to spendthrift protect them. So what does that mean? It means that that trust can be structured as a spendthrift irrevocable trust. This is a trust where we have protection from the claims of spouses, creditors, bankruptcy, all those kinds of things in the world. The only thing a trust like that does not protect against is Uncle Sam, who wants his tax, or alimony claims or child support claims. But creditors basically the beneficiaries are protected. They cannot give away their trust assets. That means that they have asset protection within inside of the trust. So structuring trustees for these trusts is one of the biggest considerations in estate planning today. Who should be my trustee? Who is the successor trustee? How am I going to be able to structure that? Should I use an individual? Should I use the beneficiary themselves as trustee, which is allowed in Maryland, but maybe not always a great idea? Should we have a corporate trustee, a bank, or a trust company? Trust protectors are used. Trust protectors are special fiduciaries that give flexibility, give dynamic control from the grave to the grantor of a trust or the testator of a will, because the trust protector can remove and replace trustees as needed. The trust protector can make amendments to the trust. So these are powerful new tools that are being used. Powers of appointment, whether we give a beneficiary the right to describe who they want to provide their further assets to, or whether we limit that to descendants. Some people would know that as a dynasty trust. These are important factors in how to structure asset protection at death. Certain ways that this is structured can provide more asset protection than other ways. And so we always want to make sure we're thinking through the design, and that's one of the biggest issues in planning today for those of you who are interested in protecting beneficiaries. Lastly, here on this list, special needs beneficiaries, but of course they are not last on the list for these purposes. We do lots and lots of special needs planning. We're very blessed here at Elville and Associates to be involved in the special needs community, and special needs beneficiaries have protection in various ways under Maryland law, the Maryland Discretionary Trust Act, and the spendthrift provisions that are included in supplemental needs trusts, trusts that are left for a special needs beneficiary from third parties, parents, siblings, and others, grandparents who are leaving money for a special needs beneficiary. Or if a special needs beneficiary unfortunately comes into money that they're not supposed to have, there are other ways of sheltering those monies in what is called a first party special needs trust. So special needs beneficiaries are protected at the death of the parent or grandparents through the use of trusts. So these are ancillary tools that we use in elder law and in asset protection in general. Now, I got a little bit ahead of myself here and mentioned the Secure Act, but I'll mention it again. This is going to affect most estate plans. It's going to effectively end, unfortunately, the ability to stretch an IRA way out into the mid-80s for a beneficiary with tax deferral, and the beneficiary was allowed to take minimum distributions. But there are those 5 exceptions I described, and there are things you can do with your estate planning to update your documents for the Secure Act and other financial advisory considerations that need to be discussed about what to do about retirement plans and the onerous or quick taxation that's going to be basically peeled out or rolled out on these inherited IRAs that beneficiaries are going to receive, and all the money will come out in 10 years. So hopefully, and Jeff, we're hopefully ending on time here. Hopefully we've given you a broad overview. I know I've talked a lot. We've tried to answer a few questions. There may be more. We talked about education today as being key, design and process being key, not looking at an estate plan as a set of documents as being key, having a lifetime approach to planning in collaboration with your financial advisory and tax team is really key. And we also promised that we would give you a path forward. So I just want to encourage you, feel free to set a consultation with us and don't be afraid. There's nothing to fear. It is a strange time in the world. We're here to partner with you. We're here to educate. We're here to help the highest and best results that we can help you achieve along with your advisory team. We want you to complete an estate planning questionnaire. This is not an easy thing to do, but that estate planning questionnaire really is possibly one of the most important things in estate planning. It encompasses all the information about you and your family, your financial assets, or you can use a spreadsheet. We want to look at the comprehensive approach to your life and your family and your situation by using that estate planning questionnaire first. We want you to bring your current documents. We want to look at those. We don't charge to review current estate planning documents, so please bring those if you decide to meet with us. We want you to have a financial advisory team and a CPA, tax preparer. If you don't have one, we want to help you form one. We have many wonderful advisory professionals that we work with, and we can help you form a team. And if you have a team, we want to meet them and we want to work with them and collaborate with them. We want to collaborate, and they should want to collaborate as well. It's not an easy thing to do, but it's something that absolutely must happen if you're going to achieve the right kind of estate planning. So that advisory team is important to work with your estate planning attorney. We want you to bring questions that you may have and concerns. Some of you have questions today, some of you have questions that you've had for years, or you have developing questions, whether they're tax related, healthcare related, planning related. We want you to bring those. And most importantly, Jeff and I and everyone here at Elville & Associates, our attorneys and staff, we want to give you the time to think through these issues. And that's why we have a process that we believe it basically fosters everything we've been talking about today. So I thank you. And I know that's a lot to go over in an hour, a little bit more than an hour. Jeff, I'm going to turn it back to you.
Well, thank you, Steve. As always, a great presentation, a lot of great information. You hit on some key ideas there: education, design, process, relationship here at Elville & Associates is important to us, and collaboration is very important with our clients, with our financial advisors. So thank you, Steve, and thank you to you, our attendees, for being here today and for the great questions. And we do have a few more here, Steve, I'd like to run by you. And we're going to be wrapping up right on time, if not a couple minutes before. So thank you all for your questions and for being here today. So the first question, as we conclude, is: my mom died during COVID without a will. I'm very sorry to hear that. She owns property in Maryland. As the oldest child, how can I apply to assume ownership of the property from my brother and me?
Thank you for that. And I'm very sorry as well. That's horrible. And our sincere condolences. I'm sorry to hear that. The answer to that question is, if your mother owned property in Maryland and that was in her sole name, and it had no designation on a deed as a life estate deed with a remainder interest to anyone, meaning it is in her sole name and it's subject to probate, then what you will need to do is petition for probate in the county where that property or where your mother resided. Basically, I'm assuming she resided in Maryland, but I'm not sure. So you would need to start a process to petition for probate, and that's something we're absolutely able to talk to you further about after today. So please just let us know if you need any help on that or questions.
Thank you. Next question is: I reside in North Carolina and was advised by a lawyer here in North Carolina in 2019 that the revocable trust and living will, etc., complies with North Carolina law. Would it be best to have all documents reviewed by a firm in Maryland, considering it seems like there have been some updates? Sorry, I lost it. Considering there have been some updates to how estates are planned.
Thank you for that question. So I'm going to make a few assumptions, and please email us offline here if you have further feedback for us. So I'm assuming you moved to North Carolina from that question. So you are not a resident of Maryland anymore, it sounds like, but it sounds like that your documents were Maryland-based documents when you moved there. And you said that the documents had been updated to, or not updated, but they comply with North Carolina law. So my question would be, have you had, if they are Maryland documents, have you had those documents changed to North Carolina as far as the situs, which is the location of the trust, and the state law? So I would do that. If you haven't done that, I would change the situs and state law of the trust to North Carolina if you are a North Carolina resident. Now that would then go to the last part of your question, which is if you're a North Carolina resident and you update the situs and state law of your trust, then I think you should definitely update or have your documents maintained in North Carolina by a North Carolina attorney or in collaboration with us and a North Carolina attorney, whatever the situation may be, because you are a resident of North Carolina. And therefore, the trust now being, let's say, a North Carolina trust, it would not be subject to the changes in Maryland law. It would be subject to North Carolina law as far as the trust goes. I hope that helps.
Thank you. Yeah. Last question is, what is the approximate fee for an estate plan and structuring a trust for a married couple? Can you send a link to receive the questionnaire? I'll be happy to send the link in my post-webinar email for the questionnaire. That's a good idea. I'll be happy to do that.
Yes, thank you for that question. So estate planning is done in many places across the country, including ours, is done mainly on a flat fee. So when Jeff sends out the questionnaire, thank you, he will send out a pricing sheet to you for our flat fee estate planning. And the flat fees depend on, what we're doing, what is the complexity or not complexity, what is the goal, a lack of complexity, I should say, what is the goal, what kind of approach are we taking? Are there special needs beneficiaries? Are there beneficiaries that need protection? Do we need a life insurance trust? There's many, many factors that go into it, but we will send that out to you, and we appreciate your asking that question.
Okay, one more. Hello, my parents have real property and financial accounts in 2 states. Both my and their primary residence are in Maryland. Is it beneficial to transfer assets to Maryland and have one set of estate plans within the state of Maryland?
Thank you for that. I don't understand the question 100%, but I think what you're saying is it a good idea to consolidate assets within one state, let's say? What I will say is, especially since you said, there's real estate in other states, I would say the main thing to do is to consider possibly a revocable living trust plan for your parents if they don't already have one. And that way, even if you don't get rid of those out-of-state properties, those properties can in some way be assigned or transferred, depending on the situation, to the revocable trust. And therefore, you're avoiding probate in Maryland, hopefully, and you're avoiding probate in those other states. So I think it's a question of consolidation in Maryland and getting rid of those out-of-state properties, it sounds like, versus using a revocable trust to just avoid probate because we know we have these out-of-state properties and we don't want probate in Maryland and in these other 2 states. I hope I've helped in that answer to touch on your question.
Okay, thank you, Steve.
Thank you.
So those are the end of our questions. If you do have a question, now would be your time to get that in. As I mentioned a couple things to wrap up here. First, thank you for your questions. Really great. They help the presentation tremendously. I'm going to be doing a few things. I always send out a post-webinar email follow-up for you that has some information. I'll include the video from today. I'll include the slides again. I'll also include our MOLST packet that I think will be very helpful to you, that Steve alluded to. And a little bit of, I'll include the questionnaire link. That's a great idea, as well as our pricing sheet. So a lot of resources for you to look over at your convenience. As far as our webinar series, on Tuesday the 12th, we have a new topic by Chuck Bork, who is special counsel here to our firm at Elville and Associates. Surprises in the employment relationship. What you don't know can hurt you. Have a lot of people signing up for that. That should be an interesting one. Also, Wednesday the 13th, what families need to know about planning for a loved one with special needs. That is our global, all-encompassing special needs planning presentation that's been very popular over the years, and we look forward to hosting you for that presentation. Wednesday the 20th, trustee selection, how to choose the right one for you, always a popular presentation we're bringing back again. And I missed one on the 19th. We have part 2 of our wellness series we just started this past week. It's the 3rd Tuesday of every month for the next several months, offered by Dr. Michelle Fritsch and Miss Ellen Platt, who's an aging life care manager we know here at Elville and Associates. The topic is navigating unexpected changes. And if this past Tuesday was any indicator, this is going to be a real big hit with people and very popular. And so I encourage you to check it out on our website, the events calendar on our website, and any invitations that come out through your email. So we look forward to hosting you again soon. I'll check to see if we have any last questions. It does look like we have one more, and then we're going to end right at 11:30. It's funny how that works. So that question is, when someone dies, does a PR always have to open probate?
Thank you. Well, I think the answer is no. There are times when there are no probate assets. And if I understand the question correctly, I'll just simply say there are times when a will of no estate, or an estate basically that has no assets, is opened. And it's basically just informing the Register of Wills that there has been a death of the person, and it's not really a true probate, but it's basically opening a will of no estate. Some people will not do this, and the Register of Wills does not enforce it and doesn't seem to care too much about it, but it's supposed to happen, and it's called a will of no estate.
Okay, great. All right, I think that's everything for today. It is 11:30 on the dot. So thank you again for being here. Thanks for your interest in our educational webinars, and hope you all have a wonderful and safe weekend. Take care, everybody. We'll see you next time.
Thank you.